On August 24th, the Mainline Suburban Life printed an article about the judicial disposition of criminal charges against a member of our zoning hearing board. The article questioned the disposition of those charges and mentioned that the Tredyffrin police officers scheduled to be witnessed at the trial were not present at court that day. The article explicitly raised the question of, quote, whether or not someone from outside the police department could have influenced a member of the police department, since the member of the zoning hearing board would be considered a township official in a position that is appointed by the Board of Supervisors, end quote. The article was accompanied by a 10-month-old captioned file photograph of the zoning hearing board member and Supervisor DiBuonaventuro. As a result of the statement in the article and the accompanying photograph, I immediately contacted Superintendent Giamo. I was informed that the police department already had started an internal investigation. I came into the police department and viewed all the charges filed in that matter. I also spoke with the district justice assigned to the case and Supervisor DiBuonaventuro. The district attorney's office also conducted a review. The internal investigation, the review by the district attorney's office, and my review found that there were no outside influence exerted on the police or the district justice. The Board of Supervisors is satisfied with the findings, and we stand behind the reputation of our police department and our fellow supervisor. However, early in my investigation, board members became aware for the first time that the zoning hearing board member had been convicted of a DUI in 2010. The Board of Supervisors does not currently have any requirements that its members of its boards and commissions disclose convictions of any sort prior or during appointment. While the conviction of the DUI did not affect her decisions on the zoning hearing board, the Board of Supervisors believes the circumstances warrant the member's resignation. I immediately contacted the individual, and she tendered a letter of resignation from the zoning hearing board on September 12th. We are currently working on a disclosure form with our solicitor so that this type of situation does not occur in the future. Finally, there was a strong reaction to what we believe were clear implications of illegal activity involving this board and our police department in the Mainline Suburban Life article and in the blogosphere. While none of us has any interest in suppressing the expression of ideas, we do have an interest in quelling unfounded, untrue implications of illegality within our township institutions, and we will always do so. We understand that certain members of our community were angered by the use of the township website for the posting of Supervisor DiBuonaventuro's statement. The board will undertake to set a policy for the use of the township website so that we avoid this controversy in the future. Thank you.
Boy, I was hoping you would say something different, Michelle, and I wouldn't have to do this. My name's Andrea Felkins. I'm a longtime resident of this community. I actually wrote two different policies because two different statements. I can hear Carol H. saying a short, thoughtful comment is better than a long, thoughtful comment. But I need to say it all. I'm here to comment on the need for a clear policy of the use of the township website. After reading what I was characterized as Mr. DiBuonaventuro's rant on township letterhead on the township page on September 6th, I immediately filled out your contact and feedback form online with my thoughts. The comments were never acknowledged. I don't even know that they were sent to you, so I'm here to voice my concerns publicly. Let me say before I start, I know three supervisors. I've never met many of you, so I'm not carrying water for anybody. For context, I was on the TE school board for 3 terms from 1991 to 2002, so I think it's fair to say I have walked in your shoes. When I read your letter, Mr. D, I'm going to call you that because I'm going to say it wrong. I wrote to you all that, and I think this was my language, I was repulsed by your response. Do I understand how you felt? I think I do, because as board president, I was the target of a well-financed campaign called Kids Count in the 90s, and I was chair of facilities when we planned for and ultimately renovated and expanded Conestoga. Even your board of supervisors made that a horrendous public experience, and I heard countless criticisms of almost any decision relating to growth in the district. We had a rancorous Act 34 hearing where the full community was present to debate the wisdom of expanding Conestoga or building a second high school. Responding to a township requirement that the district acquire additional property, we explored the purchase of adjacent land. I was told by the opposition that someone had offered to kill me to stop the district. Neighbors accused me of trying to destroy a man's life and steal his land. Were they right? Was I happy? No, but I took it. I even was the target of a screaming tirade at the Berwyn Acme in front of my children. So let me contradict what I believe to be your arrogant assertion in your public letter about this incident, because I do have the fortitude and the stamina to engage in a one-on-one campaign for elected office, and I did serve in a position with no pay, unlike your $3,000 a year. Don't applaud. This is painful, but I'm moving away, and I have to say this as I slam the door. Despite the scrutiny I took, I did it with a clear conscience. So let's start off by recognizing that you are hardly a lone ranger in finding public service complicated. But to my knowledge, you are the first person who used government stationery on a government website to lecture us on free speech and to bully someone who facilitates a forum that allowed people to question a very sketchy incident. I think I've read almost everything written about this situation, and like many, the not guilty verdict reported in the papers was unsettling on its face. I, too, agree that your picture in the news article was superfluous. I followed the story and read a lot about it in the papers, online, and in two blogs, Chester County Ramblings and Community Matters, which is why I feel confident to tell you that the only commentary about this incident that provided any information was on Community Matters. It was there that Mrs. Benson researched the topic, corrected the false impression some had that you were the anonymous driver, and ultimately shared the extensive effort the DA and the police had performed to resolve this. Mr. D, your letter made some ugly assertions about blogs and those who post on them. You seem to focus on Mrs. Benson and what you called her effort to, quote, discredit our government and its efforts to serve the citizens. You claimed, quote, that she creates and fosters an environment of conspiracy and mistrust among its limited readership. Honestly, you whined that she didn't contact you. In fact, Community Matters is a public forum. Mrs. Benson facilitates it. She does not appear to censor comments, and you tried to discredit her by saying she made the false statement that you were police liaison. What a heinous misrepresentation. She should have said you're the township liaison to the traffic committee, which is composed of township engineers and police. On October 17th, 2011, you identified yourself as the liaison to the safety and traffic people. If your website was up to date, I would actually be able to confirm who else is on the committee. Now, blogs are an evolving and growing phenomenon. In his letter, Mr. DiBuonaventuro said he believes in freedom of speech, but not in freedom of defamation. He expands that by pointing out that almost all who contribute remain cowardly anonymous. Well, I think your letter pretty much guarantees all posting will be anonymous in the future. This is an exchange of ideas and thoughts. The school district policy on communication specifically states that, quote, it is not the practice of the district or the board as a whole to participate in or review online forums such as blogs or other internet social media outlets. A worthy policy indeed. Mr. D, I'm not a lawyer, so I turned to various sources on the topic of defamation. The most relevant answer I could find cited a 1964 Supreme Court ruling on free speech in the case of the New York Times versus Sullivan. The ruling was that where a public figure attempts to bring action for defamation, the public figure must prove an additional element, that the statement was made with actual malice. In translation, that means the person making the statement knew the statement to be false or issued the statement with reckless disregard to the truth. No one knew the truth. I read the blogs and the comments and could find no evidence of any malice. Speculation, sure, but on Mrs. Benson's part, she did nothing but correct false impressions and take her personal time to research and correct the record. I would like to remind you that when the DA and the police finally issued a declaratory comment on this incident, they included the fact that as part of their internal investigation on why 2 veteran police officers both missed a hearing the morning after receiving promotions in this room, that the police had a whole page of questions for you. Mr. D, clearly after the initial story came out, the police recognized the possibility of a potential conflict of interest in play. I ask you, why were you willing to answer police questions on this topic but took such offense to speculation on a web forum that you yourself claim has limited readership? The comments on the blogs and in the newspaper commentary contemplated all kinds of things, any of which could have been resolved had there been true disclosure of the investigation of the incident. Short version, in the absence of substance, the silence was populated with speculation. Had Ms. Gleason used her position to put the speculation to rest, instead of giving you a pass and putting your letter on the website, giving it her endorsement, most, if not all of this, might have been quickly and quietly resolved. This is about a need for a policy that would dictate the circumstances that would permit or deny a member of your board to use board letterhead and post a personal letter. I cannot envision any circumstance that would have allowed this personal and angry tirade to be used in this fashion. And we know that the problem was compounded when the departing township manager vented on history and then publicly stated that the letter has the implicit endorsement of all on the board. In addition to implying that others on the board had approved the post, Ms. Gleason reasoned that the only reason Mr. D was the subject of these blog posts was that he was a township supervisor. To the contrary, the police questioned him in this case. So did they question the rest of you? I know too many of you to believe that you read this letter before it went on the website, and I know in my heart you did not authorize it. So if you do not have a policy that dictates the use of your website that would have governed this, then I encourage you to develop one. We should not permit the use of taxpayer-funded and limited access sites to vent frustrations and exercise your demons. There is no rebuttal to any township distribution. And I think we all know that the personal attack on Patty Benson, claiming that she is bent on damaging the township, as well as the childish reference to her absolute defeat in an election, went well beyond the bounds of civility. Mr. D, your letter expressed indignation and you were clearly upset, but it turned into a bullying exercise and intimidated anyone who might challenge you in the future. And in my opinion, you picked the wrong target. Patty Benson was not in any way responsible for the original story or the firestorm that followed. She did not escalate this topic. Her personal time spent talking to the principals actually helped to resolve it. It was your letter on the township website in letterhead that prompted the new scandal. The infamous letter could have gone to the source of the speculation, the newspaper or the blogs. Though I suspect had it, it would have been much less impulsive and probably wouldn't have turned against a former political candidate and almost certainly would not have named names. For a guy who wants to celebrate and focus on Paoli and its redevelopment, the hardworking chair of the Tredyffrin Historic House Tour and the chair of the Paoli Blues Fest should not be your target, and I believe you owe her a public apology. I have a packet of information with me that I will share with you. First is the letter I wrote to the BOS on September 6th. Since it was not acknowledged, I am also including a copy of what the school district website generates in response to any email contact. Additionally, I'm including policy and regulation 1100 on school district communications with the public, regulation 1122 on how staff should deal with complaints regarding the district, and policy and regulation 1305 on a code of civility as it relates to the general public. I hope you will take some time to read these, as I think they might expedite the production of a policy for this township on just when and under what circumstances a single supervisor or even the township manager can or should respond to indirect communications, much less on the township-funded website. I would ask that this board censure Mr. DiBuonaventuro for this letter. My family moved to this community in 1954. My husband and I have raised our family. We are moving away in 2013. So maybe I had the nerve to make this statement knowing I'm leaving. Your letter certainly made any kind of public scrutiny of your board a very perilous decision. I've gone on too long, as those of you who know me know I want to do. But I believe you are all experienced on the BOS what the school board has experienced for decades. The policy on communication with the public was originally written in 1969. You all are just experiencing the growing pains of public scrutiny in these difficult economic times. For as long as I can remember, the school board has been subject to second-guessing, scrutiny, criticism, and yes, the occasional thank you. We do it for the kids. You, along with other board members in this community, are all part of serving us, and the community very much appreciates your time. We validate that each election. I'd like to close with one comment. You want our vote to do your job. Well, in return, we want truth along with your respect when we question it. Thank you.